Bank of the Philippine Islands versus the Intermediate Appellate Court in Zshornack. Is it Zshornack? So the facts of the case is in here. On October 27, 1957, an application of a dollar draft was accomplished by Virgilio Garcia, Assistant Branch Manager of Comtrust, Quezon City, payable to a certain Leo Vigilda D. Dizon. Tapos hanggang dito yan sa when Zshornack noticed the withdrawal of $1,000 from his account, he demanded an explanation from the bank. In answer, Comtrust claimed that the peso value of the withdrawal was given to Attorney Ernest Zshornack, Jr., brother of Rizaldi, on October 27, 1975, when he, Ernesto, encashed with Comtrust a cashier's check for $8,450 issued by the Manila Banking Corporation payable to Ernesto. Ayun, and of course, pumunta sila sa Court of First Instance. Tapos pumunta sila nanalo si ang Zshornacks, tapos ang Bank of Philippine Islands nag-appeal sa Intermediate Appellate Court, and the Intermediate Appellate Court gave three judgments. So number one, ordering the defendant Comtrust to restore to the dollar savings account of plaintiff number 25-4109 the amount of $1,000 as of October 27, 1975 to earn interest together with the remaining balance of the said account at the rate fixed by the bank for dollar deposits under Central Bank Circular 343. And second judgment, ordering defendant Comtrust to return to the plaintiff the amount of $3,000 immediately upon the finality of this decision without interest, for the reason that the said amount was merely held in custody for safekeeping but was not actually deposited with the defendant Comtrust, because being cash currency, it cannot by law be deposited with plaintiff's dollar account, and defendant's only obligation is to return the same to plaintiff upon demand. And the third judgment is ordering defendant Comtrust to pay plaintiff in the amount of 8,000 pesos as damages in the concept of litigation expenses and attorney's fees suffered by plaintiff as a result of the failure of defendant bank to restore at his account the amount of $1,000 to return to him the $3,000 cash left for safekeeping costs against defendant Comtrust. So Bank of the Philippine Islands, the petitioner, filed for certiorari ata yun. Yes. And then they went to Supreme Court, and here's the decision for the first where is it? Wait a minute. Okay, here it is. First judgment. The document which employee embodies the contract states that the $3,000 was received by the bank for safekeeping. The subsequent acts of the parties also show that the intent of the parties was really for the bank to safely keep the dollars and to return to the Zshornack at a later time. Thus, Zshornack demanded the return of the money on May 10, 1976, or over 5 months later. Above arrangement is that contract defined under Article 1962's New Civil Code, which reads, a deposit is constituted from the moment a person receives a thing belonging to another, with the obligation of safely keeping it and returning the same if the safekeeping of the thing delivered is not the principal purpose of the contract. There is no deposit but some other contract. Here, note that the object of the contract between Zshornack and Comtrust was foreign exchange. Hence, the transaction was covered by Central Bank Circular Number 20, Restriction on Gold and Foreign Exchange Transactions, promulgated on December 9, 1949, which was enforced at the time the parties entered into the transaction involved in this case. So yun yung decision sa judgment number 1 ng the Intermediate Appellate Court. So the second one is here. The second one is in here. Okay. As earlier stated, the document and the subsequent acts of the parties show that they intended the bank to keep the foreign exchange and return it to the Zshornack, who alleged to his complaint that he is a Philippine resident. The parties did not intend to sell the US dollars to the central bank within the one business day from receipt. Otherwise, the contract of depositum never had been entered into at all. Since the mere safekeeping of the greenbacks without selling them to the central bank within one business day from receipt is transaction which is not authorized by Central Bank Circular Number 20. It must be considered as one which falls under the general class of prohibited transactions. Hence, pursuant to Article 5 of the Civil Code, it is void, having been executed against the provisions of a mandatory prohibitory law. More importantly, it affords neither of the parties a cause of action against the other, when the nullity proceeds from the illegality of the cause of the or object of the contract, and the acts constitutes criminal offense. Both parties are in pari delicto. Pari delicto. They shall have no cause of action against each other. The only remedy, one on behalf of the state to prosecute the parties for violating the law. So, hindi na, na-modify yung second judgment ng Intermediate Appellate Court. So, wala na to. Ito, wala na. Ang dumi ng kuko ko. So, so the first one was approved. Second one was not approved because they are in pari delicto. Next, the third one. Lastly, we find that the 8,000 awarded by the courts of Co as damages in the concept of litigation expenses and attorney's fees to be reasonable. The award is sustained. Wherefore, the decision appealed from form is hereby modified. Petitioner is ordered to restore to the dollar savings account to private respondent the amount of $1,000 as of October 27, 1975, to earn interest at the rate fixed by the bank for dollar savings deposits. Petitioner is further ordered to pay private respondent the amount of 8,000 as damages. The other costs of action of private respondent are ordered dismissed. So yun. So na-approve din tong third, naka number 5 lang yan kasi 5 yung judgment nung ng court of first instance. Tatlo yung inapprove ng intermediate appellate court. Tapos pagdating sa Supreme Court, dalawa na lang, which is ito, then ito. Okay? And tapos na sa case na to, na-touch din yung about the official of the corporation. Sabi kasi ng bank alleges that Garcia exceeded its authority and the obligation is purely personal to Garcia, which is hindi nakumbinsi ang Supreme Court. So hindi dapat na kay Garcia lang yon. It's for the entire corporation. Yung decision na yon, yung paggawa ni Garcia ng action, which is to what do you call this, convert the US dollars to peso and put it in their peso current account. Yun. So I hope nakatulong. Yun yung Bank of the Philippine Islands versus the Intermediate Appellate Court and Zshornack.